Hey, I'm Mike Alder. Thank you for watching this. You know, our firm got notice of a remote jury trial that's coming up, and we had more questions than we had answers. And we figured, you know what, why don't we just try to do a mock trial remotely? We'll film it and we'll see how it comes out. So I called one of my good friends, Mike Schonbuch, one of the best defense lawyers in the country. Another very good friend, Judge Brian Hill, a Superior Court judge here in California. We had 8 jurors and we had 4 witnesses. So we recorded the entire remote trial together, and we're going to play it in 3 sections. The final section is going to be closing arguments and the discussion from the jurors, the judge, and the lawyers who were involved. And then we're going to have everyone who would like to participate get an email survey, and we're going to have questions and areas for comment, and then share the results with anyone who wants them, any bar organization or any court system that would like the information.
And I would be addressing Mr. Schonbuch and Mr. Alder. So let's just assume that we have none of the jurors present. Mr. Schonbuch, Mr. Alder, welcome back. As you know, we're outside the presence of the jury. I've received jury instruction from Mr. Schonbuch and Mr. Alder. Do you have any other special instructions you want to give to the court for review?
None, Your Honor.
No, Your Honor.
I'm going to do the standard jury instructions, and it doesn't sound like there's any special. So what about verdict forms? Have you prepared those, Mr. Alder?
Yes, Your Honor. We agreed to a verdict form. We've already, we actually didn't even put the causation question or liability, and it's just a damage question.
And you've reviewed those, Mr. Schonbuch?
Yes, Your Honor.
For the record, they're acceptable to you?
Yes, they are, Your Honor.
So, Mr. Alder, I haven't had a chance to look at the verdict forms, so why don't you email those to me so I can review them as well?
Yes, sir.
And then let's talk about the process of how we're going to get those verdict forms. And I suppose we probably want a single or maybe multiple copies of the jury instructions to send into the jury deliberation room with the jurors. So what I propose to do, and I'm kind of thinking out loud, you may have a different approach to it, but we'll designate, for example, juror number 1, just for purposes of receiving the documents as the jury foreperson. So I'll send the verdict forms to juror number 1, and at some point the jury is going to be deliberating. They're going to be deliberating digitally or remotely. Nobody else will be present, and so, Mr. Schonbuch, let me begin with you. Maybe we send a copy of the verdict forms to every single juror. I mean, it's easy to do. I'm going to email it. Mr. Alder is going to send me the verdict forms. I'll email those verdict forms to each individual juror. I'll give them the instructions about picking a jury foreperson. So it doesn't have to be, so maybe just sending them to one juror doesn't make sense. Have you thought about that process at all, Mr. Schonbuch?
Yeah, I think the way it probably is going to work the best is the attorneys have to agree upon the stack of jury instructions and agree upon the verdict form, and then those are sent to the court, and then the court would then send them out to the jurors.
Yes, sir.
And I suppose, whereas if this was a in-person jury trial, we might send in 3 or 4 copies. But one of the benefits of doing this Zoom jury trial is once I approve of the set of jury instructions that the court will read to the jurors, that I can send every individual juror a copy of those instructions as well as a copy of the verdict forms. And then I'll modify the jury instructions so that even though everybody has a copy of the verdict form, only the jury foreperson will sign the verdict form. And then in terms of notification of the court, ordinarily we'd have a clerk, so we could have the jury foreperson email the clerk that a verdict has been reached, or perhaps not reached, but that the jury is basically complete with deliberations. And then the clerk, maybe you've thought about this, the two attorneys, but I suppose the clerk could then notify the court that the jury has reached a verdict, and then perhaps the verdict forms. Have you thought about whether they should be delivered direct? So ordinarily they would go to the bailiff and then to the court, or to the bailiff, the clerk, in the court, and I'd review them, send them back to the clerk. Every court does it a little differently. Have you thought about that? Let me ask you, Mr. Alder, about that process.
Oh, sir, I think any way that avoids the lawyers getting it first is probably fine with me. I mean, if the clerk or the judge or the bailiff gets it first, I'm fine with either.
I suppose, you know, part of just thinking out loud, because I haven't done plenty of Zoom hearings, but I haven't done any Zoom trials, jury trials. But we have our jury foreperson the verdict forms have been filled out. I would think that it might make sense just to have them email directly to the court. Then I would have them, I could review them. The clerk would read them. I think in this instance, maybe it makes more sense for the court to read the verdicts. And is that acceptable to both sides in terms of process?
Yes, Your Honor.
Yes, Your Honor. You know, I think it seems to me that maybe each court should end up creating a new email address that is the contact address. So the jurors send in their information to that email, and then the lawyers to that email, and then the court can send it out to whoever they want, but like a separate email address just related for each trial is what I'm thinking is probably the best way to do it, communication-wise.
And what would be the purpose of that?
I'm just saying, for a communication back and forth. So if the court wants to talk to the jurors and not the lawyers, then there's a dedicated email address back and forth. And the same thing with the lawyers and the court, like a separate just email address just for trial. That's just what I'm thinking, just for communication.
So I'm not good with technology, but it's easy to set up that separate email address. And then what you're suggesting is that maybe at the beginning of the trial, that separate email address for this particular case would be given to the jurors. And if either they had questions or for the verdict form, they would use that email address.
Right.
But
that way it's just, there's nothing else in that email address. There's nothing else but that trial. Just easy direct communication back and forth.
At the, Your Honor, at the, when we play this live, edited live, we're going to have a survey, and that'll be some of the questions about people making comments on what they think is the best system, that kind of thing, which we'll share with everyone.
Have either one of you, I mean, I don't want to take up too much time because this is, I mean, we've already been here for over 3 hours, but have either one of you, are you aware of separate email address being used in other cases for a specific case?
I have not.
Just an idea I came up with.
Yeah, no, it's interesting. All right, well, let's end our breakout session. I have the jury instructions. I think I'm going to dispense reading with the jury instructions, but I'll give I'll make a few comments to the jurors when we bring them back from this breakout session, and then we're going to launch right into closing arguments. Are you both prepared to proceed?
Yes, Your Honor.
Yes, Your Honor.
All right, let's go back on the record in the case of plaintiff versus defendant. All jurors are present. The attorneys are present. Plaintiff and defendant also present. Ladies and gentlemen, welcome back. Sorry it took a little bit longer. The attorneys and I had to discuss a few issues, including jury instructions. I had to review the verdict forms, make sure they were all complete and accurate. And I will have a few instructions to read to you, but at this point, both sides have rested. And the attorneys will have the opportunity to make closing arguments to you and even rebuttal arguments if they think it's appropriate. Plaintiff has the burden of proof. It's preponderance of the evidence. You've been instructed on that burden of proof at the outset, and you will be again. So there's no ambiguity. This is a civil case, and the burden of proof is preponderance of the evidence. So, Mr. Alder, would you like to make a closing argument?
Yes, sir, I would. Thank you.
You may proceed.
Thank you. Okay, good afternoon, everybody. And I want to start where I started in opening statement. That's by thanking you. And, you know, we all watch you like a hawk. Even remotely, we watch you like a hawk. And one of the things that I noticed is how attentive you all are and how much you pay attention. And I know that that means that you're going to deliberate fairly and think about the evidence. And the evidence is really important because I believe when you apply the law that we're going to talk about, the evidence shows clearly that we have proven our case. And I want to talk about that. So again, thank you very much. And, you know, the judge said the plaintiff has the burden of proof. What that means legally, and I'm going to put up the jury instruction that says what the burden of proof is. It's a preponderance of the evidence, which really means more likely than not. It's different than a criminal case. A criminal case, if you put somebody in jail, you got to be like certain, almost certain. In a civil case, because as you've even heard in this case, that sometimes stuff doesn't make sense. It can't be always 100% consistent. The plaintiff has said a couple things, the defendant, and if you were required to be certain, then it would be very difficult in a civil case because things like that happen. So where money's involved, the burden of proof is more likely than not. In other words, which thing probably happened? And if evidence weighs even slightly in favor of one of the plaintiff's side, you can say, well, it probably happened that way, and then award money to the plaintiff. So I want to go through the evidence, and I want to talk about it in terms of if the plaintiff has one side and the defendant has the other. When you put the evidence on this scale, that's why we have a scale of justice. If the evidence that the plaintiff has tips the scale even a little bit, then we win. We have proven our case. Now, as we go through this, I think I'm going to show you that when you apply the law, it's actually really quite a lot. So the first question is, when you go back there, juror number one is the foreperson. He is going to take you through the evidence, and you put it on one side. Did it help the plaintiff or hurt the plaintiff, and help the defendant or hurt the defendant? And at the end, if the plaintiff's evidence outweighs the defense, then you award whatever you believe is fair to the plaintiff. There's a couple jury instructions that help you figure out how much weight to put on evidence. And so the first one is when you weigh a witness's testimony, if that witness says something that's not true or that is inconsistent, or they seem to not to be shading the truth, you can ignore that testimony or all of their testimony. Like, for example, and you know, I know I kind of overemphasized it, but it was relevant that I kept asking the defense doctor about his memory because he made a big deal about how smart he was, right? And so you can ask yourself, should I believe everything he says, or is he capable of picking and choosing? Why would someone who is so proud of a perfect GPA not remember even ballpark how much money he makes from forensic work? And you can say, well, that means he's picking what he remembers. He's shading the truth. And he doesn't want to tell us because he thinks it will make his side look bad. And that's being an advocate, not being independent. And so if you believe that that doctor should have remembered more, even ballpark, and he's not doing it on purpose, you don't have to believe anything he said. So when I ask questions, well, why do you say the tests say one thing and the treating doctors say the test says something different? You don't have to listen to the defense doctor's version of what the tests say, because you can discount his testimony because he's shown that he's willing to shade the truth. You can do that with the plaintiff, with the defense, and you don't have to be sure, right? Mr. Schonbuch, for example, I just want to be straight up. He pointed out that the plaintiff said at the hospital that the impact was light. That doesn't necessarily mean that the plaintiff is a liar. It means whatever it means. But if on balance you believe that the plaintiff is telling the truth, if he was treating reasonably, conservatively, he was trying his best, then it could be that he was stunned, feeling bad, not sure what happened, doesn't even remember saying it. The same applies for the defendant. So what have we shown in terms of the plaintiff's testimony and the defendant's testimony? Well, to me, the most important thing is the plaintiff says the impact was substantial, and the defendant says the impact was non-existent. Which is probably true? Well, we know there was $4,500 worth of damage. That's more consistent with the plaintiff. We know that the defendant said she was going 4 miles an hour or slower, and the scientific unrebutted testimony says she wasn't correct by a factor of 3. Even more likely. Now, they both said that they were yelling at each other, but if an older lady who is being called an old lady, threatened by a much younger man, screaming at her to where she calls 911, doesn't say anything to the police, ask yourself, is that consistent? No. Again, more likely than not, the plaintiff is the one who's correct. And then lastly, when you look at the plaintiff's behavior himself, if he truly was making this up, why would he wait to go see a doctor to take surgery? He tried conservative treatment, tried to underplay his testimony, his injuries, hoping it would go away. That is not consistent with that player of the system that Mr. Schonbuch has been alluding to. Right? So is it more likely than not that the plaintiff is making all this up, or he's just doing his best? He's a hardworking person who wanted to work and hoped that this went away. It didn't go away. It got worse over time. It started to localize in one area, and we focused on that. Thank God he got a lawyer. If he didn't, Mr. Schonbuch would be running roughshod over him. Thank God he got a lawyer who got him to the right physician, and over the next year and a half got conservative treatment in hopes that the surgery wouldn't happen. Now he's stuck. Now he's stuck as a 38-year-old with whether he can withstand the pain or have surgery. And that's going to be with him when he's 48, when he's 58, when he's 68, when he's 78, and God willing, when he's 88. 40 to 50 more years. So we all read about verdicts and we read about numbers and everybody says McDonald's coffee or whatever it is, but you are facing exactly what real life jurors have to look at. They have to look at a gentleman who did nothing wrong, who did everything that his doctors told him to do, conservative treatment, and he incurred $72,250 worth of medical bills, and the defendant is accepting responsibility for none of it, despite doing nothing wrong. So when you weigh the evidence, more likely than not, he is entitled to be reimbursed that money. He has a surgery that was recommended by board certified surgeons who have seen him multiple times over a year and a half that have no dog in the fight. For $35,000, he is entitled to be provided that money to have that surgery. And then he's going to have, over the next 40 to 50 years, in addition to the last year and a half, some level of pain and suffering. Now, one of the things that we call someone in pain over a long period of time is chronic pain. That's what we describe it as. It's well known that people who are in chronic pain, whatever they do, however they get in their bed or they move, they can't get rid of all their pain. That is what drives us crazy. That is what makes us miserable. When you are laying in bed and no matter what direction you put your body, you've got some level of pain. Moralizing, it is difficult to deal with. A 38-year-old healthy man who is athletic, did nothing wrong in an accident, and from that point on has had chronic pain and is looking at that for the rest of his life, is why we're here. So this isn't some money play. This is a request to think about and compensate someone for 5/8 of their life. And so you're going to get a verdict form, and it's going to ask you first, what amount of money was Mr. Plaintiff's medical bills past and future? And I believe you should write $107,250. The second question is, what amount of money for past and future pain and suffering? For the last year and a half, I believe that a fair and reasonable number is $75,000. But now when we talk about the future, we're talking about 40 to 50 more years. Now, the 8 of you will decide what number is correct. The judge has read an instruction that says we can suggest what we believe is fair and reasonable, and you can use that as part of your consideration. But if you really go through every day, right, that's 14,000 days. I believe an award of future pain and suffering of $250,000 is not unreasonable. So when you add all those numbers up, it's going to be a big number. But if you have gone through the law and the facts, and you've weighed all the evidence, and you have at least 2/3 of you have agreed to the number, even if it's a big number, you have a verdict. And the reason it may be a big number is because it's a long period of time and because it's a big deal. So the last thing I want to say before I turn it over to Mr. Schonbuch is there is one jury instruction that I have found over time has confused people. It's confused me, and I think it's an unfortunate use of words that I want to talk about. And there's a jury instruction that says substantial factor. And the question is, for every amount of damage that you are asked to award, the question is, was this accident a substantial factor in causing that harm, causing that pain, causing that medical bill? And the reason I say it's unfortunate, because in everyday life, we hear the word substantial, and we think, well, that must mean this accident has to be some catastrophic event that is substantial, that changes life forever. But in a legal context, I'd ask Mr. Foreperson to pull it out and show it to everyone. In a legal context, substantial is defined as anything that is not trivial is substantial. In other words, there can be 1,000,000 substantial factors as long as it's not some trivial event. The single thing that changed in the plaintiff's life from a healthy, pain-free, athletic, hardworking gentleman to someone who has pain chronically was this accident. if you believe that this accident was more than a trivial factor in making that pain happen, then you must, under the law, award every single penny that is reasonable to compensate the plaintiff. Really appreciate again how attentive you all have been, how much I can see that you want to be good, fair people to both of us, and I know you will. I look forward to talking to you one more time after Mr. Schonbuch has a chance to address you. Thanks very much.
Mr. Alder, thank you. Mr. Schonbuch, go ahead.
Thank you, Your Honor. As I said at the outset of this case, this trial is about a difference of opinion. It's about a dispute over the amount of money plaintiff should get, if any. This was a minor accident with minor injuries. And if plaintiff were to receive a verdict in this case from the jury, it should be a small amount of money to reimburse him for the inconvenience of having to go to a doctor just to get checked out. Why do I say that? Because this accident is a plastic fender bender. It is a minor accident with a minor impact. How do we know that? We're going to look at the evidence, the objective evidence, not what plaintiff says, because that's subjective. The objective evidence is undisputed. And we're going to compare the objective, undisputed evidence to the subjective, what a person says, evidence. So let's look at some of these issues. First of all, the plaintiff's airbags did not deploy, correct? Absolutely. Undisputed, objective. There's no weighing of the evidence. Everyone agrees. There was absolutely no damage at all to Ms. Defendant's Ford. Nothing, not a scratch. If there was some massive, big damage to that Ford, plaintiff was there, he was at the scene, he had his phone. Take a picture. The reason there's no picture is, the reason he didn't do it, there was nothing to photograph. He wouldn't want to take a picture that shows no damage. This was such a big, huge, smashing boom impact. Then take the photograph instead of yelling at Ms. Defendant. There's been a lot about that, about yelling. I mean, think about that. I understand plaintiff being aggravated. He's on his way to work. He's got a big meeting. He gets into this minor incident, but what happens now? He's going to be late. He's got to make calls. The police are coming. It's understandable. You get aggravated. He's trying to say that she's the one sitting there and yelling when she's apparently spending her time to go raise guide dogs for blind people, and he's on the way to a work meeting. Who is going to be the one who's going to be upset here? The police were called by Ms. Defendant. They came to the scene and didn't make a report because it was such a minor accident. It's objective. It's undisputed. No report. If there was a report, we would have heard about the report. There would have been testimony about the report. No report. The reason was undisputed, like Ms. Defendant said. There were no injuries, no complaints. Everybody was fine. Police looked around and left. Plaintiff didn't call an ambulance at the scene, correct? Objective, undisputed. If he was that hurt, you would say, you know what? I need to be taken from the scene. Paramedics, ambulance, undisputed. Plaintiff doesn't go to the doctor from the accident scene, does he? Oh my God, I'm hurt. I got to go to a doctor. Of course not. Objective, undisputed. Don't look at what a person says. Look at what they do. The actions speak louder than words. What does he do? He spends his entire day, he goes to work. He doesn't take a half day. He doesn't ice his back in the office. He's not walking around with a heating pad. He didn't tell you, hey, I had to take Advil or Tylenol. I couldn't make it through the day. Nothing. Didn't go to the doctor. Instead, he went to work. Didn't go home early to rest. Nothing. Completely objective, completely undisputed. When he finally does go to the doctor that evening, what does he do? He drives himself there. He doesn't have to call 911 or call an ambulance or call a paramedic or call a taxi or call a Lyft or call an Uber. He's well enough where he stands up, gets into his car with no problem, drives himself over to the hospital, doesn't have to go in through the emergency entrance, parks in whatever lot, casually walks in, Hi, I'm here to see the doctor. Are these the actions of someone who says, my life is ruined, I need surgery for the rest of my life, and money for every single one of my remaining 14,000 days? These are objective. Look at what the person does, not what they say. So what happens when he goes to see the doctor that night? What does he say? The impact is light. That's what he said. The impact is light. Now remember, a year later, he's already seen the personal injury lawyer, right? He's got a lawsuit. He's asking for money. He's having his deposition taken. All of a sudden now it's a boom. It's an explosion. An explosion. There that night, says right to the doctor, the impact was light. It was light. Light. So what happens? He tells the doctor no loss of consciousness. It's right after the accident, same day. No loss of consciousness. Later on, though, I don't know. I was stunned. I may have lost consciousness. I don't know. It's like a year later, all of a sudden, his memory's crystal clear. It's like if we wait another year, it'll get even better. He'll have even more information. I think it's pretty reasonable to say that a person's memory is most crystal clear right there and then. No lawyers, no lawsuit, no claim for money. It's just the plaintiff and the doctor before we get to this point. You got to compare that. Mr. Alder wants you to weigh, Mr. Plaintiff lawyer wants you to weigh the evidence in the case. So why don't you weigh what he says, the plaintiff says a year later, after the lawsuit and all that, he knows he's asking for money. That's what the case is all about. He's got a personally injury lawyer who's referring him to doctors. You want to weigh the statements. Go back to the pre-lawsuit that night and the way he describes the incident and compare that and weigh that to what it looks like, the description of this massive accident, according to the plaintiff a full year later. Anyway, what did the doctors there do that night? They took x-rays. Everything was 100% normal, undisputed, objective. These are x-ray films. You ever hear the expression, a picture's worth 1,000 words? Those x-rays cannot be disputed. If they could be disputed, we would have heard some dispute from the plaintiff and the lawyers and the experts, but there's no dispute, 100% normal. What do? They sent him home, discharged. He's not admitted to the hospital. He's not even given pain medication. He comes in, nothing, not even a pill, not one single pill. They discharge him that night, sent him right home with nothing, no further care, no instruction. Basically, if you feel pain, sure, go get yourself some Advil. Over-the-counter medication, it's called. Not even enough to warrant a prescription. What happens next? Plaintiff goes to the lawyer, remember? He didn't go to his home. He didn't go to his regular doctor, his primary care physician. He went to a lawyer first. And the lawyer referred the plaintiff to a lawsuit doctor. That's a doctor that gets referrals from the lawyer and then guides the plaintiff and the lawyer, everybody through the lawsuit process from the medical perspective. Now, all of a sudden, what do we got? It's a massive impact. It's a boom and it's an explosion. Maybe there was loss of consciousness. We're going to get injections. We're going to talk about surgery. We're going to get medical bills. We're going to have the lawsuit. You want to do a comparison? Who are you going to believe? The doctors at the hospital handling real trauma cases, catastrophic, massive accidents, gunshots, and code blue situations with no interest at all at this lawsuit. They don't even care about it. They don't know about it. Or the doctor, compare that to the doctor who has a waiting room full of people who come there referred from the plaintiff personal injury lawyers who say, hey, we have a lawsuit. The person's claiming injury. I need you to take a look at them. You want to do a comparison of weighing? Why don't you weigh those two? Let's look at more objective evidence. Cervical spine MRI, completely 100% normal, undisputed, no issues, everything is perfect. Low back MRI, the first one and the second one, degeneration, not caused by an accident. Desiccation, not caused by an accident. Disc disease, not caused by an accident. Again, picture's worth 1,000 words. Those images do not lie. They are objective. You don't need to swear them in under penalty of perjury. No one's taking the deposition of an MRI. You don't have to weigh, balance the MRI. It's objective, undisputed. There it is. It's a picture. And by the way, did you ever hear of an accident causing a disease? Trauma does not cause degeneration. Trauma does not cause desiccation. Trauma does not cause disease. None of these objective, undisputed low back issues are caused by an accident. Then plaintiff was examined by an outside doctor, the doctor that I hired. Why do we hire a doctor? Because when you're faced with a lawsuit and a claim for money damages under the law in California, you don't have to just sit back and go, okay, tell me the number. I'll just write you a check. What do you want? $100,000, $250,000? You want $250,000? Hey, no checkbook. I'll just write you a check. It's not the way it works. You can have an outside doctor. The law says you can have someone review the evidence and meet the plaintiff and examine them and say, what's going on here? I'd like to take a look at this. So that's what we did. And yes, we heard a big deal about the fact that our defense doctor went to Harvard and graduated #1 in his class and provides free medical care at clinics and things. That's right. A guy who provides free medical care in clinics. He was examined by the plaintiff was examined by our doctor hired by me. Every objective test is normal. Reflexes, motor strength, neurological exam, range of motion, all the different maneuvers. Okay, those are objective exams. Subjective means, ouch, that hurts. Objective is like a reflex where you hit the knee with the hammer and the knee triggers. You ever hear of anyone faking a reflex? Can't happen. It's objective. Can't fake a blood test. Can't fake an x-ray. Can't fake an MRI. But you can say, ow, that hurts. Or, ooh, I never had any pain whatsoever, ever in my entire life until this little accident. You can say that, but you can't fake a reflex. The question for the jury is called causation. Substantial factor. Did this little minor accident that didn't even scratch Ms. Defendant's Ford or hurt this 65-year-old retired special education teacher, this guide dog raising woman, didn't cause her any discomfort, any distress, any pain, any medical bills, nothing at all? Did it really cause plaintiff to now need a back surgery? Now on this issue, it seems to me, I'm not sure, but it seems to me that plaintiff is trying to argue that it's almost like a before and after situation. Well, you know, I had this accident and now I need surgery, so I guess the accident is what caused the surgery. And that's not the way it works. Legal causation is not before and after. It's a substantial factor. It actually has to cause it. Before and after is like saying, you know what? Hey, I wake up every morning and I make myself a cup of coffee, and about an hour later, the sun rises. So therefore, my cup of coffee rise because I had my coffee and then the sun rose, and every day it happens. That's before and after. That's not causation. My cup of coffee has absolutely nothing to do with the sun rising, just like the accident has absolutely nothing to do with degeneration, desiccation, and disc disease. That's what's on the films objectively. And by the way, on this surgery, if plaintiff really needed the surgery, he would have had it already. Have it. It's not even scheduled. It's not even on the calendar. I asked whether it was scheduled, not even on the calendar. You're really going to have it? Set it for December. Set it for January. You know you got to go in for your pre-surgery check, get your heart checked and get your blood work done. It takes time. Put something on the calendar. Had he come into court, come into trial and said, my surgery is set. It's December 12, 2020. I'm going in for surgery. all right, you know what? Maybe you are going to have the surgery. I don't think the surgery was caused by this accident, but maybe you're going to have the surgery. But it's not even scheduled. It's not even on the schedule. That's something to weigh. The cause of this pain, what's going on here, is the aging process, the pre-existing degeneration, desiccation, disc disease caused by tackle football and baseball and basketball and softball. That's what just happens when the body gets older. It's one thing when you're in your 20s, but it's another thing when you start to be in your 30s and approaching 40 now to be playing. That's what happens. It's very unfortunate because everyone who gets to that age goes through that same desiccation and degeneration. But that's what it is. This trial is about a difference of opinion. It's a dispute about the severity of this accident, a dispute about the amount of money plaintiff is to receive, if any. The plaintiff's verdict in this case should be, at most, a small amount of money to reimburse him for the inconvenience of having to go to a doctor and just get checked out. So please go ahead and give him for his visit to the hospital that night. It's reasonable to get checked out. No dispute with that. Go ahead and pay him for the plastic cosmetic damage to the Prius. And by the way, speaking of that, before I forget, all that damage to the Prius, the $4,000 or whatever, remember they took away off the $5,000. Now it's just the $4,000. It's all undisputed. It's cosmetic. There was no damage to the car structurally, no damage to the frame, no damage to the tires. Didn't even have to be realigned. The wheels didn't have to be balanced. The frame didn't have to be straightened. Even the bumper wasn't hurt. Nothing. Just the plastic bumper cover. I asked plaintiff's reconstruction expert, isn't it true that all this damage is classified as cosmetic? She said yes. Cosmetic means just to make the car look good. It's painting. Not even the rear window broke. So don't forget that when weighing the accident, the cosmetic plastic damage. Anyway, go ahead. Pay him to make his Prius look pretty again, the cosmetic damage. He can have the cosmetics to make it look pretty. We have no problem with that. Go ahead and give him some money for his inconvenience. A couple of thousand, but whatever. I'm not going to sit here and throw a number out of the air. Pull a number out like, oh, it's $250,000. It's 100. I'm not going to do that. I'm going to allow the jury to decide what's right and what's fair, to pay him for the inconvenience of having to go get the car fixed and go to the doctor and get checked out that night and have the x-rays. I got no problem with that. But that's it. No surgery, no lifetime. And by the way, speaking of surgery and lifetime, don't you think it's kind of odd that the plaintiff wants all this money for the surgery, but at the same time wants money for lifetime pain and suffering? Don't you think it should be kind of either or? You're having the surgery and you're saying, I need the surgery to help my pain. Why are you then saying I'm going to be in pain for the rest of my life? If you are, then don't have the surgery. But wants money for both? Anyway, I'm going to leave that up to the jury to figure out what number to give him for the inconvenience of this accident. At this time, I want to say thank you very much for your attention in this case. Before I stop, I want to tell everyone about what's going to happen next. Plaintiff's counsel is going to get to go again. The process is called rebuttal. Rebuttal means that the plaintiff goes twice. He gets to speak twice as many times as I do. Why is that? Because the plaintiff has the burden of proof. That's why he gets to go twice. Now, a lot of plaintiff lawyers will come to court and tell you, or over Zoom will tell you, that it's ever so slightly, the tiniest little bit is the burden of proof. And they do that because they know, you know what? This is kind of a close call here. I don't really know. That's why it's such a tiny. The bottom line is the burden of proof is very, very important, which is why the plaintiff gets to speak again, gets to go twice. Please understand, you have to know, no matter what plaintiff's counsel says during rebuttal, you all know that I have something to say in response. I would love the opportunity to be able to make a comment back for whatever he's going to say about me or what we've done in this case. But I don't get that opportunity because plaintiff has the burden of proof. And that burden is so difficult to overcome that he gets to go twice. I don't get to say a word. So before I sit down then, what I want to say is, since I don't get to speak again, why don't you ask plaintiff's counsel during his rebuttal to answer this question for you? If this was such a major, huge impact, this was such a big monster boom and explosion and all that, then why is all the damage to the Prius cosmetic with no damage to the frame or the bumper? And why does he have to pay thousands of dollars to an accident reconstruction person to try to come in here and tell you about these forces involved in this little baby accident that didn't even hurt Ms. Defendant? It's so easy and obvious. What does he got to do that for? Anyway, let's see what he has to say about that. Again, thank you for your time and your attention. And again, I'm going to ask you to find in favor of Ms. Defendant. Thank you very much.
Mr. Schonbuch, thank you. Mr. Alder, rebuttal argument.
Thank you. So I will tell you that the rule of law is not a difference of opinion. You do not decide based on one opinion or a difference of opinions. It is law, and it is facts, and it is science. And I was interested because while Mr. Schonbuch was waiting to figure out what questions he should ask me, I asked, am I going to hear any law, any science, any facts? No. And that should be noted. You are smart people. Ask yourselves, why is he talking about what the defendant does in her spare time? Is that relevant to the law, to the facts, to the science? Why is the defense expert talking about him helping indigent children? Is that relevant? Now, it's a wonderful thing, and I am not degrading that in any bit. It is not a popularity contest. It is about law, which we've shown you, about facts, and about science. Let's address some of that. Mr. Schonbuch talks about cosmetic. Well, that is considered in the thousands of tests, crash tests done of the type of damage, whatever you call it. That damage equates to a certain force. And if there was frame damage, that force would be even more. But whatever you call the damage doesn't take away from a certain amount of force was required to cause that damage, unrebutted. So they can call it minor, they can call it cosmetic, they can name it whatever they want. Whatever name we put on it is equal to the force that it took to cause that damage. And that force is completely consistent with these injuries, what the plaintiff says, and completely inconsistent with what the defendant says. We talk about objective, there it is. How many times do we hear minor, 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 cosmetic, whatever, but those are just labels. It is not addressing the facts or the science. So let's talk about x-rays. Well, if you don't break a bone, which we never have alleged happen, the x-rays are always going to be normal, always. It's irrelevant. If you don't have a front end impact of a certain speed, the airbags never go off. So saying it's minor, it's cosmetic, the x-rays, what the defendant does on her spare time has nothing to do with this case, but has everything to do if you don't want to talk about law, facts, and science, but you want to talk about opinion, which you have not heard the judge talk about ever. That's because we want people to make fair decisions on the facts, not on popularity. The reason we don't know if there was damage to the Ford was because the defendant didn't take any photographs of her vehicle. It's gotten to the point where he's saying, oh, well, the plaintiff should have taken photos at the scene. But you know what we would have heard if he had done that? Oh, he was clearly thinking about manufacturing this claim from the get-go. You can't win either way. If the plaintiff runs to the orthopedic surgeon and has surgery immediately, now we're going to be argued that he was running to doctors. Instead, he did what a normal law-abiding, hardworking person does. He didn't want to go with an ambulance. He wanted to see if he got better. He tried. It didn't get better. He went and thankfully got a lawyer who could explain that this is not about opinion. He tried to get better. It didn't. He tried conservative measures. After a while, you realized he didn't, and now he's at surgery. There is no evidence that he could schedule that surgery in COVID with any particularity. So when Mr. Schonbuch says, well, it would be more real if he had scheduled it, is a complete guess by Mr. Schonbuch. Again, it's not about opinion. It's about facts, about law, and about science. I submit to you that what the plaintiff has done in every circumstance has shown that he took the lesser invasive route, the more conservative route, and only went to a more expensive, more difficult route when required to due to his pain. Last couple things. The evidence that you heard from the plaintiff when he talked to his treating doctor is that if he gets the surgery, it will help, but after about 20 years, it will come back. And so that lifetime of pain it's going to change at different times, but at some point it's going to come back when he's older. And until that time, he's got to worry about that. So this is a lifetime injury. The pain may differ based on how old he is, but as he gets older, the pain's going to get worse. So this is not something that we're making up. You heard it from the stand. Last couple of things. Mr. Schonbuch said that the treating physician, a board certified doctor, is a quote lawsuit doctor. No evidence of that. But he does know that lawsuit doctor resonates with the community. If you've read about frivolous lawsuits, that is not like this case. In fact, the only evidence we know of is that the defense doctor, Mr. Schonbuch, has done a number of cases together. But the reason we don't have specificity is because the defense doctor can't remember even a ballpark. Let's see, they could have photographed the car, but they didn't. They could have told us how much work they do together, but they can't remember. How much money do you make? I can't remember. But we can remember that we help children in need. We can remember what we do in our off time. Again, I'm not denigrating that. I'm saying kudos. Thank you for doing that. But understand that doesn't have anything to do with this case. And the reason they're bringing it up is so that you will look away from the facts, the law, and the science. And so, ladies and gentlemen, when you weigh the evidence, plaintiff versus defense, you not only outweigh a little, when you truly look at it, it is clear that we have proven that every step of the way the plaintiff has done the conservative measure, and we're only here because the defendant accepted responsibility for rear-ending, but has not accepted any responsibility for what she actually caused to the plaintiff. I appreciate your attention. I look forward to your verdict. Thank you very much.
Mr. Alder, thank you, ladies and gentlemen of the jury. Thank you for your patience. You're about to begin deliberations. As you know, you're going to do your deliberations by Zoom. This is new technology that we're using in the courts. But when you deliberate, it's going to be like if you were to deliberate if all 12 were in the same room. It's only going to be the 12 of you who are conversing with each other and discussing the case with each other. If at any time one of the jurors has to leave, the discussion about the case ends. You only get to discuss the case when all 8 jurors are present, and that's the only time. So absolutely under no circumstances are you to do any deliberations with less than 8 people. All 8 have to be present. We're going to send in to you the exhibits. We're going to send to you each one of you will have a copy of all of the exhibits. Each one of you will get a copy of the jury instructions. I was prepared to read the 30 or 40 minutes worth of jury instructions, but I think it's appropriate to dispense with that in this particular case. I see some smiles among you jurors. So, especially among the two attorneys. So you will get the jury instructions, you'll get the exhibits. You have my email. I think we sort of tentatively talked about juror number 1 being the 4-person, but if you choose another 4-person, that's okay. It's up to the jury to make that decision. When the jury reaches a verdict, send an email to me directly. You have my email address. If you have any questions about the law in the case, or you have any confusion about maybe what one of the attorneys said, you can send a question to the court directly. I'll try to answer it. I'll confer with the attorneys. So it may take some time before I'm able to respond to the question. But any kind of question that you think would be helpful to deliberations, send it to me directly. And it should be sent by the 4-person. All right. Again, thank you for your service. We'll be seeing you in a few moments, but we're going to send you into our virtual jury deliberation room to begin your deliberations.
So thank you, Judge. Guys, we decided we're not going to have the jurors deliberate, but if Your Honor can kind of run a discussion.
Sure.
You know, the whole purpose of this was to run through it to see what problems, what issues, how it works, good, bad, and otherwise. And I would propose that we go through the jurors 1 through 8 and just give us your thoughts, your comments. If there's something that you liked, didn't like. One of the things we tried to do was Mike sat down, I stood up. Sometimes we were big on the screen, sometimes we were little. We had different backgrounds. I tried to have a screen behind me, but it wasn't big enough. So I had to show you the house. But, you know, the doctor's in his waiting room, in his, in his doctor's room. So, Your Honor, if you don't mind taking us through and just, some thoughts. When
Sure.
we show this, we're going to have a survey that people who watch it can also make comments as well.
So before we get to the jurors, I think one of the things that's helpful to the court is that when we're doing this Zoom trial, I'm able to see myself and notice my own facial expressions. You all can see me. It really puts me to the test of appearing to be impartial and listening to the evidence. Perhaps some of you as well. During the course of a jury trial, sometimes the testimony gets a little dry and a little tedious, and it's hard for even the court to pay attention. That's impossible. It's impossible not to pay attention when everybody's looking at me on the screen and I see myself on the screen. So I think that same phenomena also exists for the individual jurors. You're looking at yourself, and others, others are looking at you, whereas that's not necessarily the case in a jury box, where juror number 1 might not be able to see juror number 6. So I think that's a positive in terms of ensuring that everybody pays attention. And from time to time, we all know that becomes an issue. I thought the whole trial went extremely well. We weren't able to do, the sidebar, which I think is a little bit tricky. But other than that, I was very impressed with the use of the technology.
I agree.
So, any feedback or any comments, juror number 1? Mr. Choi?
Do you mind if I go last, Your Honor?
Yeah, no, that's fine. I'm just going to go across the top of my screen. So, Mr. Contreras, anything that struck you as good or bad about the conduct of the trial?
Well, just procedurally, sometimes there was a noise, and that's resolved by the notification, disabling of the notifications of your email. And I think that happened with mine as well. When we have our speaker on and an email comes in, there's going to be like a noise, that was kind of distracting. And also, this is something that we can't control as well, and that happens to me during depositions. You'll cut off, and then, it'll mess up the flow. And sometimes, the deponent or the witness will say, look, I didn't hear you, can you repeat it? That kind of messes up the flow. But in terms of the actual substance, yeah, Mike Alder standing up really worked for me. I think Mr. Schonbuch, I think at one point said, I'm gonna sit down now and I'm done or something. And I said, wait, I thought you were sitting down the entire time, because that's how it looks like. So that was funny. But, you know, for me, I would definitely prefer the attorney standing up, because I feel like they have more control over it. When you're sitting down, I feel like you're stuck, you know, like to me, it's a little bit more awkward. That's my perspective, of course. And in terms of the background, I would prefer a more natural background, because when people use the virtual background, it seems disingenuous to me. Like, okay, what are you hiding? What's back there, you know? So when it's just a natural background, that works better for me. I think I would prefer a more blank background, because, you know, Mike Alder, your paintings were kind of distracting me at one point, you know, the very nice paintings. So I just wanted to see what's back there. But other than that, you know.
I think that's a
You
good
were
point.
saying?
It's true. If you have your couch in the back and a couple photographs and paintings and so on, that can be a bit distracting.
And you know what's interesting is the reason for that was we weren't prepared. We thought we'd have a white sheet background that would cover, and when we did it, it was actually covered about this much of the screen. And then we're like, okay, let's take down some paintings so we have a blank wall, and then we didn't have it, right? So it's a good point. I can't imagine what the rules are going to be when we're remote as to what is allowed in your background. I assume you got to clear a white wall or something. I don't know.
Yeah, that wouldn't be allowed, I wouldn't think. But
Yeah.
that's something I would have thought of until Mr. Contreras brought it up. I mean, it's true, it was distracting, but as a judge, I'm not sure I would have thought about that pre-trial and issued the order for the attorneys and witnesses to appear with just blank.
I think sorry to interrupt, but I think the lawyers and maybe even the expert witnesses would also need to be cautious if they, you know, like Mike, your house looks very fancy to me, so I might think of you as a greedy plaintiff's attorney. I don't, you know, you have to be careful.
No, I get it. That's, and in part, this was done to have different backgrounds for comments just like that. It's kind of like, you know, like you don't drive your Ferrari to court, you drive your beat up old Bronco, right? And you have, I get it. Yeah.
Mr. Contreras, let me ask you one other question. You're at your office and you're using your computer at the office. And so, so you said when you were getting emails while watching the monitor, it would interrupt you. It made it difficult for you to hear the testimony. Is that what I understood?
That was for the person who was actually speaking, because anytime there's a speaker who's unmuted and they have a notification in their computer, that noise is going to sound for everyone as well. So I think, I don't know whoever was speaking, a notification came up and I heard it and it kind of interrupted the flow of things, especially, and I couldn't hear it as well when, you know, they were speaking, of course. But it wasn't mine, it was whoever was speaking at that time. But I think that did happen to me one time when I was actually unmuted. So it's whoever is speaking and unmuted. But if, let's say there's multiple speakers, whoever's notification comes up, that will also come throughout the general sound as well. So you got to make sure that the notifications are off on your computer for that to not come up.
That's interesting.
And this is a Sunday also, which most of us probably are not getting as much email traffic. I would imagine on a Monday, if you're doing a Zoom trial, I get 600 to 800 emails a day during the week, but on the weekend I get like 10. So that could be a big issue.
That's a good point. Mr. Lacy, any thoughts, comments?
Yeah, I've got a few. Thank you for asking, Your Honor. So, I mean, there are some substantively, but there are also some, I guess, I don't want to say performatively, even though I guess trials are performance in some regard. I definitely noticed a difference. I can't both call you Mike, so I'm gonna have to call you by your last names. I noticed the difference between the sitting and the standing. Alder, you got a great voice, right? And you also have a great presence. Sometimes that's hard to come through through the Zoom, right? Part of the effect of you standing is to see your body and to see your movement, you know, and maybe if the frame, I don't know how you do it, but so you can see, you know, you standing and things like that. Yeah, but then you seem real far away, you know. Then you seem real far away in distance. So I don't know how to work that. But you know, I think in some instances it did take away from your emotional appeal. Now in other circumstances where you're able to get close and you really be endearing, you know, to the jury, I thought, you know, that worked. But I think just the format of a Zoom trial may favor the defense because it makes it a little more impersonal, you know? It makes it a little colder, a little cut and dry, and the defense could take the emotion out of things and think about things, I guess, specifically and as Mike, as Schonbuch would say, objectively, right? And I would say that goes for things about, you know, when the defendant is being examined about the screaming and the interaction, he's flailing his arms and things like that. It's somewhat compelling because you get to take out the, I guess, the physical demonstration that Alder, I know you want to bring in, you know, of the quickness of the jerk, right? You did the clap, right? You did the clap. That goes well in a court, not because you get the acoustics and everything like that. I don't get that same thing here, right? But in the same instance, I thought, you know, your cross of Mr. Defense Doctor, what'd you call him, Dr. Defense? I thought that was very effective, right? I thought that the background kind of played against him in that regard because it made him seem very stuffy and unreal. And that's where your personality then began to come through, right? You begin to see like a real person. And whereas he was some type of man, not to disrespect you or anything, doctor. he seemed like a manufactured, you know, defense expert.
See, I wanted to hire David as my expert, right? I like that. You come work for us.
You know, when you mentioned, and they paid you $27,000, I would imagine a lot of people on the jury would probably look at that like, whoa, $27,000, that's a lot of money, right? Or something I thought on the other side, when Schonbuch, when you were talking about the football injuries, one of the things I did notice, and I'll agree with Your Honor, is that we couldn't see everybody, you know, if it's on just the speaker view, right? But anytime I saw or I heard Mike Schonbuch mention that the sports injuries and things like that, jurors number 8, number 3, and number 7, I saw you all sit back, just, you know, like, oh, like, yeah, well, you know, I don't know what that's about, right? But maybe that appealed. Or I can't really tell what interaction or how they felt about it. There was some reaction, but because I can't really see them, it kind of takes, maybe there's a different discussion we have in deliberation, I don't know, but it kind of takes the live effect out of it. You know what I mean? You know, I thought at least as far as getting things on the screen, that worked pretty well. Obviously, you have to really kind of be a director, making sure exhibits are taken down, and making sure that you're not being a distraction when somebody else is speaking or whatever. But, you know, I was surprised because I wasn't expecting that a Zoom trial would even be feasible. For me, I was like, oh, no, totally, no way.
Oh,
but after seeing it, I'm a little more open to it.
Juror number 4, Boris.
Yes, thank you, Your Honor. So a couple of things I noticed is definitely gauge the distance between the camera and yourself. Maybe have it to chest and above, because I noticed both of you like to talk with your hands. So sometimes when you were talking, it would just come up like underneath the camera. Something is trying to come up on the screen, but then you wouldn't see it fully. So maybe gauge that distance in the sense that you're able to use your hands properly. And with that being said, also be, um, I was cautious on like your tie or what you were wearing. Like I noticed Mike Alder had his ring on and his watch on. So definitely like keep that in mind what you're gonna have on, because like the camera could zoom in. Another thing that I did is during the opening, I put only speaker view, and that was way more effective. It just made more connection and me paying attention. And during the closings, I did a gallery view where it was a little bit distracting because the yellow tab was on the speaker, but at the same time, you're gauging to see what's happening with everybody else. And, it kind of takes it away from it. So maybe during opening and closing, have everyone be on the speaker view. That way you make it more interactional with them. And during maybe when they're crossing someone or something, just have the gallery view just to see what's going on between the two speakers. I don't know if
That's a great suggestion for the court to instruct the jurors that when you have a particular witness on, use the speaker format and not the gallery view. I kept mine on gallery view the whole time, which is probably appropriate for the judge, but that's a very good point. And that's really a judicial obligation at the outset of the trial. Juror number 7, Ms. Gonzalez.
Thank you, Your Honor. I apologize for my Wi-Fi connection at the moment, but I do echo a lot of what my fellow jurors have been saying and have been suggesting. I also wanted to place my suggestion of being mindful of possible Wi-Fi shortages, and in the event that someone's Wi-Fi cuts out and they do exit the Zoom room, the adjustments that may happen within those situations. For example, mine did cut off, so I did have to like adjust and come back in. But just seeing how that can be sorted out. But I do really feel that this experience was really engaging, and at some points really intense. So I felt really like really into it, I guess you could say. So, while this is not the kind of experience that we had been hoping for, given the current circumstances, I do feel that, it was executed very well.
Mrs. Heatherman, juror number 3.
Thank you, Your Honor. Yeah, basically my comments are along the lines of the logistics, and I completely agree with all of the other kind of critiques that have been pointed out. When in speaker view, I did that particularly in the opening arguments when Mr. Alder was speaking, and then the defense attorney, he made some kind of sound, and so my attention was then diverted to him and him readjusting while Mr. Alder was speaking. So just being mindful and maybe figuring out, should everybody be muted when somebody is speaking, because the views can change so quickly, which can be really disruptive. And then the other thing I kept thinking of is, how are jurors going to be not going to go online and look up information about the other attorneys or the experts, because I found myself wanting to be like, who's this doctor? Did he really go to Harvard and get a perfect GPA? And it's so natural just to want to look up that information. And obviously in a courtroom, you can't do that, but I don't know how you're going to stop a juror from looking up anything and everything. I have my phone right here. I could be doing whatever I want, and you can't see me down here. You can't, unless I show you my hands all the time, you don't really know what I'm doing or who else is speaking to me. My son came in and wanted some cereal, and I'm moving my foot not to talk to me. So those exterior possible distractions are a big concern I kept thinking of throughout the trial. But
it's a good point, because during the course of a regular trial, during whether it's deliberations or otherwise, presentation of evidence, we repeatedly admonish the importance of not using outside resources. So we do that. But typically when somebody, a lot of times it happens inadvertently, get some information about the case from another source, it's another juror who reveals it. So that's going to be a lot less likely that another juror is going to be aware that a particular juror has accessed some outside information that they've used in their deliberations. It's just less likely because they're not going to have that one-on-one exchange during a break where one juror says to the other, well, where did you learn that? Or, I didn't understand that was the meaning of substantial. So that's a good point. That's going to be, I think, a greater risk with this format than with in-person jury trials. Mr. Chen?
Yes, hi, thank you, Your Honor. So yes, my comments are all along the lines of logistics as well. So the first thing is, I think jurors need to ensure that they all have adequate hardware to support hours of Zoom calls. You know, not every member of the community is going to have a computer, is going to have a video camera to their laptop, computer, microphone. Some may use their cell phone, and not everybody may have an iPhone or an Android. So if they do use their cell phone, they've got to ensure that there's adequate battery, that it's always plugged in. Another thing is the internet connection. Yeah, my internet connection cut out as well, just because there was a power outage here, so that could present an issue. Another thing is, the neutral background for everyone. You know, we don't know what's in jurors' houses. We don't want to show anything that's inappropriate or whatever the case may be. It should always be a neutral background. And another thing is, the final thing I have is distractions. You know, how are you going to control jurors not surfing on the internet all day rather than paying attention to the trial? So I think those are the three main points I have.
You know, you raise a really good point with regard to people from the community not having the sort of resources that would allow them to participate in a Zoom trial. So, I mean, it occurs to me that the court is going to have to provide, in a way that doesn't embarrass any particular individual, it's going to have to provide those resources. Maybe, you know, we'll have to think, I'd have to think about that, but that's an extremely good point. And that invitation is going to have to be made in one form or another, that they can come to the courtroom, and we'll provide a laptop in a room where they can participate in the Zoom trial. I mean, that's going to happen. Otherwise, the cross-section, the constitutional right to a cross-section of the community is going to be impacted. Juror number 8.
Yes, Your Honor, thank you. So I think everybody mentioned pretty much everything on my list that I was writing. But I think one of the things that was not mentioned is, like, today was a fairly, like, really small trial in terms of length. And so everything went smoothly and way better than I expected. But if it's a longer trial, the concentration span of the witnesses is something that we should be mindful of, and how we present evidence, right? Right now, everything was verbal, oral. Like Mike started speaking, and we were never shown anything other than the little exhibits. But if it becomes a longer trial, then that is going to be very important, because you're going to lose witnesses if you keep talking, or they're going to get sleepy, they're going to get hungry, they're going to get tired of being sitting down for long periods of time. So I thought that was something to be mindful of, that none of the rest of the people have mentioned, and maybe we should consider at some point.
Yeah.
So, Michael, I'm going to leave. I have to go. You all might want to continue this discussion, or maybe not. I see we're almost at 2 o'clock. So I want to thank everyone for participating and for the invitation from Mike Alder. I enjoyed it. I think it was extremely helpful to the court. I haven't asked you, juror number 1, any comments, any further thoughts about the case?
Just a couple. I wasn't sure how to answer the question. That's why I wanted to go last. But I found myself thinking, if the decision is in the hands of the jury, I kept looking at all the jurors to see if they were sleeping, paying attention or not. In a way, I thought that was a good thing. But obviously, I want everyone that's involved in the process to do their best. And I thought it was great that I could make sure everyone was paying attention. Otherwise, I thought this was an awesome experience.
Yeah, it was pretty interesting, very informative. Like, helpful to you, Mr. Schonbuch?
Judge, I don't want to keep you. There's some stuff I wanted to talk to everybody about in terms of just procedure, and but I want to, can everybody, thank you. Judge Brian Hill is amazing.
Thank you.
It's terrific. Thank you, Your Honor.
It was very informative.
Thank you, Your Honor.
Enjoyed it.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
All right.
No, let's just stay for just another couple minutes. Judge, if you, whenever, and thank you. So let me just say, one of the things, and I've been texting with Schonbuch while we're doing this. And first of all, the witnesses, the lawyers in the, you guys were dynamite, really excellent. Everybody, thank you very much for obviously putting a lot of time and thought and really getting into character, and that was wonderful. Mike Schonbuch, you see why he's the best in the business, defense lawyer, just dynamite, very good friend for a long time. One of the things we wanted to do was, now we're gonna edit this, take out some stuff, but we're gonna start promoting it. And I think the plan is we're gonna try to play, maybe divide it in 3, and play Thursday, then play the second session on Tuesday, and then the next session like the following Thursday, so that people can watch opening, whatever, then they can watch the witnesses, and they can watch closing and discussion. And then we're gonna do through SurveyMonkey, we're coming up with questions about, for a survey, so whoever watches it online, if they want to participate in answering a survey, a lot of questions, just like we're talking about. So as further participation, if there's stuff that you're thinking about that you guys would like to know, well, I wonder what the general public would think about. We're going to do stuff like backgrounds and standing and sitting and that kind of stuff. But if you all have any idea, please just email certainly you can email me, but we got Edward and Bianca in the office as well. Right? And then the thing I got out of this one is that this is doable. I mean, it's doable, right? And the last thing we want to do, especially with trials being kicked forever and ever, is say we're not going to go to trial because it's remote. I think this maybe shows us, certainly on shorter cases, that plaintiffs, we should agree to Zoom trials. We should not be pushing this. And maybe we can give the best of both business. And I don't know about even private remote trials where, kind of similar to some form of arbitration, trial arbitration. Again, all this for plaintiffs is suggesting it to the defense, And, Mike, tell us, you had that experience with where the plaintiff's lawyer said, we want to go with the remote, and you said, let's push it. And I guess the court has to make a decision.
Yeah, look, I'll tell you, going into this thing today, I knew we would get through it, but I thought it would be a logistical nightmare, and it wasn't. It was actually, once you get all the work done ahead of time and get it set up, it can be done very smoothly. I was not convinced that this would be a viable option until we did this program. And when I say this, I mean actually doing real cases. Now that I see it happen, I think it can work. I think especially the small to medium size cases that require less court time, I think we should be able to do this way. The larger ones, if it's 2 week, 3 week, 4 week, 5 week, 6 week, I think that's going to be a problem. But there's way more of the small to medium sized cases that are taking up space in our system because of the backlog we're having now due to the delay. And if we can get some of these cases tried, it'll help the court system. It'll help the lawyers because it'll give us work and it'll get cases settled and resolved. And it'll help the clients, the plaintiffs as well, because they can get their cases resolved. It'll help the defendants because the insurance companies, they can't keep stacking up pending cases. They got to get files closed. So, because new ones are coming in. So, I don't know. I think this can actually work.
Yeah. So everyone, thank you so much. I cannot tell you how much I appreciate the effort. I will ask a couple more things. One, when you get the survey, go ahead and fill it out so we can compile hopefully a large group of responses that we're going to share, like I said, with the court, with the BOTA, with SoCal, with CALA, CAOC. And then also, once we start, we're figuring out right now how best to ask people to watch this. We'd ask that you guys also help promote it, to however we promote stuff. And I think clearly the plaintiff won a ton of money, clearly.
was a defense verdict, right?
I agree too.
But this is a very, very, very common fact pattern. And Jennifer Burks, thank you so much. She put all this together.
Yeah,
Amazing.
thanks, Jennifer. Thanks, Jennifer.
Very
You're welcome.
Lori,
I really am still here.
Lori's
Thanks,
very
Jennifer.
accident recon. David, you were definitely the hard
Lori
one,
did it.
right? Jaffe.
You guys were great. The witnesses were fantastic. I think, I got to tell you, Mike, I think this can work. Maybe people will start loosening up a little bit and saying, okay, I can go, because the bottom line is until the trials get back cooking, whether it's Zoom or live or whatever, until there's the verdicts, the whole system's going to be stagnant. It just is. I mean, and that's going to hurt everybody. It's going to hurt plaintiffs. It's going to hurt defendants. It hurts all of us.
I agree. So we're all going to get low impact rear ender.
Half a day trials.
Right. Hey, when I first started, you get to a trial in a half a day from 9 to 2, man. When I first started during trials, we would show up on Monday. The jury would get the case on Thursday. We would get a verdict on Friday, and we were done.
Yeah, exactly. Me too.
It was great.
Thank you all
Mike,
very
Mike,
yeah.
are you using like a teleprompter kind of setup for your camera? Because you look when you talk, you're looking. It looks like you're looking right at us.
It's called a box of koi food. Right. No. And again,
cool.
This is my laptop, and Edward has like a fancy camera, but we're like, no. Then there was like a light that he had on right here, and we decided to turn that off and just go real. And again, I think it's good that we'll get eliciting a lot of responses about the background, but this was not our intent. This was literally, our intent was to go just flat. The problem with the Zoom created backgrounds, as you all know, is it makes you disappear sometimes, and and even with a green screen, it still makes you disappear. But I think a white background for everybody is going to make it even more difficult for people to stay awake. That's the problem. I like that y'all have, and I'm trying to figure out what Schonbuch's artwork is above his head, right?
That's funny. All right, let me show you what we have. Schonbuch's idea of artwork.
Oh, it's a mirror.
We have Black Sabbath.
Oh, Black Sabbath.
We have Rolling Stones. These are all autograph lithographs. I've got dozens
That's
of them.
awesome.
He looks in the mirror.
Thank you all very much. Have a good weekend.
Thanks, guys.
Thanks, guys.
Bye. Bye.
Thank you. Thank you, Mike.
What I was really happy about was the questions that we had. We decided to jump in and just do it. And we answered a lot of questions. And as we realize, justice delayed is justice denied for most of our clients. And what we all came away with is that this is doable. This is viable. There are things that you need to experience to figure out what works for you, but every one of us can do it. So I just wanted to thank everybody, from Judge Hill to Mike Schonbuch to all of the jurors, the lawyers in our firm that participated as witnesses, Jennifer Burks in particular, who put this whole thing together, everyone who helped in the filming. It was a collaborative effort, and everyone jumped in and really made it possible. So thank you, and I hope everybody enjoys it and gets a lot out of it.